We will now resume the afternoon session, and I will invite Mr. Rowe to address us on behalf of the respondents. Mr. Rowe.
My Lord, I'll follow, if I may, broadly the scheme of our written case, but I want, if I might, just to preface that with a sort of broad overview of what I'm intending to say. Essentially, it is this. We submit that, first of all, as is perhaps uncontroversial, the statutory scheme is such that the marketing of petroleum products is prima facie prohibited. It needs the minister's license for it to take place. It's envisaged under the statutory scheme that that will take place under the auspices of a license which is granted by the minister on application to the minister, or the result of a renewal of a license. That does not appear to have been done in the present case, but certainly before the board, we accept that the minister can't be heard to say that in those circumstances these appellants had no license at all. In effect, the position is we accept that the appellants had what the Court of Appeal described as de facto licenses. But we submit there is necessarily to be implied into such a de facto license, as the Court of Appeal said, the power to revoke it in the event that there is a failure by the deemed licensee to comply with the material obligations that the deemed licensee is deemed to have undertaken. And we say that for essentially three reasons. First, because that's what section 17(1) of the Act says the license has to contain. Secondly, insofar as necessary, we say it by reference to the Interpretation Act that you were taken to this morning by my learned friend, Mr. Knox. And thirdly, and this is a new point, although I've given my learned friend notice of it, we also say there's actually an express provision in the Act in section 33, which I'll come back to in due course. And that's the reason why your lordships have also got, in addition to the pre-prepared record, the full copy of the Petroleum Act, which was sent across this morning. Because for whatever reason, the copy in the record stops at the end of section 30. But I'll come back to that in due course. So we say, in the light of all of that, there was plainly a power to revoke. We say there was also, by necessary implication, a power to take steps short of a full revocation, namely to suspend, in circumstances where there reasonably appeared to the minister to be a material breach of obligation. And we respectfully submit that that is actually what happened in this case. We say that there is no basis for saying that there was simply a decision to revoke, and that what happened was that there was a suspension of these two deemed licenses. They, as it happened, expired by a fraction of time while they were suspended. And there's no proper basis, as we submit, for that to say that there was a revocation. And that in those circumstances, that really that is all there is to it. And there was no, finally, we say no unfairness in the way in which this was all done, such as to give rise to any cause of action on the part of the appellants. So that's the broad overview of it. So far as the facts are concerned, you weren't taken to these in any detail by my learned friend, consistently with his submission that really this was a pure question of law that the learned judge had to decide. I'll come back in a moment, if I may, to why we say that's not quite the right way to look at it, and your lordships will have seen what we say in our printed case about that. I did want to just touch briefly on some of the factual evidence, accepting, and I'm going to take the board really to some of the ministry's factual evidence, accepting, of course, that presents the ministry's side of the story, and that there are responsive pieces of evidence from the appellants. I mean, well, can we start what I hope is a fairly brief review of this, at least to get some of the flavour of it, in the first volume, page 280. What we find here is the affidavit of Mr. Denoon, on behalf of the minister, and he describes. We're talking now about the Prakash case. He describes the investigation that took place and the visit that took place on the 28th of November, 2012. And your lordships will see that at the bottom of the page, he says that at this service station, I observed 3 rooms which were examined by the team. He describes the rooms. He talks about the fact that they contained steel tanks equipped with distribution lines and connecting valves, and goes on with further description, the detail of which I don't need to go into at the moment. And then at paragraph 7, he says, based on the foregoing readings, he's talking about readings he's taken with a meter that he's got with him, I determined that there was the presence of a suspected unauthorized substance with a relatively low higher explosive limit, which could have posed a fire stroke explosion hazard for the nearby community. And he goes on to give further description about other things that he found: a second room behind sheets of what he calls galvanized, various tanks in that room, and a further third room, again with large steel tanks in it. That's all I wanted to ask your lordships to look at in relation to that affidavit. The next one is at page 330. Yes, my lord.
Yes, sorry, I just wanted to check my understanding. I think Mr. Danoon is a safety inspector with NP, the licensee. Right.
I'm sorry, Lord, you cut out slightly. Could you say that again?
Sorry, yes, he's the safety inspector with NP, the marketing company.
Yes.
Which is the licensee under condition 9 of the old licenses. Is that right?
It's the company that supplies the petroleum. Yeah, I think it's the state petroleum company that supplies the petroleum to the station. And
yes.
but I think your lordship is right as to who it is in relation to that contract, the license agreement.
Thank you very much.
Yeah. 330, which is where I was about to go to, is the affidavit of Mr. Ramdaheen. And he explains that he is in fact the chief mechanical engineer attached to the Ministry of Energy and Energy Affairs. And he describes, again, what happened. He prefaces this detailed description of what happened with what he says at paragraph 8, which is that the assets in the energy sector which handle petroleum or petroleum products are high risk because of their potential to cause a major catastrophe with possible mass casualty, injury, damage to property, and environmental damage. And he then goes on, as I say, to describe, at least from his perspective, the visit on the 28th of November to Prakash's station, picking it up at paragraph 17 on page 334. He says that Mr. Fraser, who was with him, who's from MP, approached Mr. Prakash Maharaj, sought his cooperation to open locked areas at the back of the service station for the purposes of inspection. Mr. Maharaj had earlier indicated he did not have the keys for this area and maintained this position even after our arrival. However, after Mr. Fraser spoke to him, he returned with the keys and opened the area for our examination. The area was hidden, says Mr. Ramdaheen, behind a galvanized gate to the service bay area of the station. And he goes on to describe what he found in paragraph 18. He says that he found in what he describes as an area, a warehouse facility for carrying out a secret or hidden petroleum operation, and storages with inventories, is the word he uses, perhaps quantities is perhaps what one might want to say, of petroleum products, pipe works, hoses, connection fittings, and pumping equipment. He says he asked Mr. Maharaj to account for what was there, what he'd found, and was told that it was excess fuel from service trucks which could not be accepted into the underground diesel tanks. In other words, I suppose when somebody turns up to deliver but there's too much to fit it into the underground tanks. He asked Mr. Maharaj, he says, to explain how NP's tank wagons and other contractors' tank wagons were able to deliver fuel into these elevated tanks when they were equipped only for gravity flow and have no pumping equipment. Mr. Maharaj provided no answer. And it goes on to describe other aspects of the visit. And there is a reference at paragraph 21 to the discovery, as Mr. Ramdahin puts it, of the condensate, which he says at the end of that paragraph is dangerous, unstable, and unsuitable for use in modern vehicles or for blending with conventional fuels. He explains at 22 why he was unable to take photographs, because his camera employs flash photography and the room had a strong hydrocarbon-based odor. A flash from my camera could have resulted in an explosion. So that's why he doesn't take photographs. And my lord, there's more in a similar vein, which I won't take time by trawling through, but at paragraph 30, he says, after considering and analysing all of the foregoing factors, which is a reference to a long list of concerns, a unanimous decision was reached to direct the temporary discontinuance of the sale of fuel products at this station. NP officials and the ministry officials present, including myself, noted the concerns and issues cited were very serious, and it was necessary to suspend operations to avert any disaster. This was done in the public interest. And he then goes on to explain, to say how it was explained to Mr. Maharaj at the time that's what they were doing. Later on, he explains they go off to Twister's compound, which is the residential compound of Mr. Maharaj. And he says at paragraph 41 that, before I get there, I skipped out top of page 341. He says also that in relation to the service station, it would have to remain closed until the ministry completed its investigation and a determination was made. And that he says he explained this to Mr. Maharaj. But reverting to Twister's compound, he gives a description of what they found at Twister's compound, where he says he observed a large shed barricaded with galvanized sheets. That's the bottom of para 41. And took pictures there of a number of large tanks, all of which contained, he says, appeared to contain a substance like diesel, and he explains that the total estimated volume is between 2,000 and 3,000 gallons of diesel fuel there. Lord, again, I can cut, but essentially there is a summary at paragraph 58 where Mr. Ramdahin, that is, explains what he says he told Mr. Maharaj at the time about the unsatisfactory nature of storing all this diesel at the site. It carries a significant subsidy which the state through the MEA was funding, and therefore the state had a legal right to verify it. And he goes on to describe subsequently at quite some length, which I won't go through, how they acted after that and ensured that the fuel was removed, and so on and so forth. Subsequently, my lord, I think we can put that to one side for the moment. Subsequently, there were investigations into the quality of some of the fuel, and that you can see in volume 2 at page 594. This is an analysis of the fuel back at the service station. It's a technical report, it's a letter, a covering letter explaining a technical report dated the 12th of December 2012. And it's describing what happened, tests that were performed on various samples. And the essence of it is that various different samples were taken. They all revealed fuel that was not fit for use. Your Lordship will have seen, I think, briefly the notice, but perhaps I can just ask your Lordship to turn it up. I'm sorry, that does in fact mean going back to volume 1. It's page 252 in volume 1. Notice of non-compliance. We're still here on Prakash's service station, the one at Fayazabad. And your Lordships will see that it sets out what is said to have been wrong that they discovered in the course of the inspection. 53, unauthorized warehouse, inventories of dangerous petroleum products, unapproved petroleum storages, it says at paragraph 2, unsafe conditions at paragraph 3, dangerous atmosphere in the enclosed storage room, that's at 3A, absence of safety, forgive me.
Yes, I just wanted to check in relation to the letter at page 253 at B. It's claimed in the letter that Prakash said that the fluids were condensate, but I think that that allegation is not carried through in the affidavits.
Your Lordship may well be right. I'm afraid I can't recall whether it's carried through in the affidavits. I must say my recollection is that it was, but Your Lordship may be right, but it's not. But in any event, the ministry's concern was about the fact that this appeared to be condensate. I can't put it at the moment, I think, any higher than that.
Yes, in fact, I think we looked at the relevant passages in Mr. Ramadin's affidavit, and he didn't support that allegation. Anyway, I just wanted to see if you wanted to say anything about it. Thank you.
I think Lordship may be right about that. So, Lordship, reverting to the letter, there is further description of things that are said to have been wrong with the service station on 254, unapproved modifications, unauthorized petroleum fluids. That's a reference to the condensate that we've just been talking about. And at the bottom of page 254, what it says, as you can see, is that the service station was declared unfit for continued operations, was cordoned off, and operations suspended pending outcome of further studies and investigations. It is noted you did cooperate by handing over control of the subject service station to NPMC. And over the page, it says that this is cause for handing over a notice of non-compliance. That, as we've seen, was the 18th of December 2012. There is then, some while later, it must be accepted, a ministry report on Prakash, which is the thing that we find at page, volume 2, again, page 529. Just ask your Lordship to turn that up briefly. This has a helpful executive summary starting at page 534. And if we pick it up at 536, we can see that it says that the inquiries have revealed various things, and we get essentially a similar list of problems that have been highlighted, that are highlighted as to what was discovered at the service station. Major unauthorized modifications, irregularities. And there are further points there which I haven't gone into detail of, but further irregularities, for example, in connection with quantities of diesel being delivered. All of this is disputed, of course, I accept, but there are further irregularities said to have been found in relation to what was going on at the site. And this document, which is an investigation report, does say at 537 that given the gravity of the breaches committed by Mr. Maharaj, the Minister of Energy must revoke and debar Mr. Prakash Maharaj from operating his service station. That's about 3/4 of the way down page 537. But as we know, of course, and my own friend took your Lordship to this morning, the ministry report was then provided to Prakash with a request for comments about it at that stage. My Lord, the next thing I wanted to show your lordship, or take your lordship briefly, was one further affidavit by Mr. Ramdahin. That's at volume 3, 1196. He deals with various further things we needn't go into, but in what I mentioned it in the present context because he deals with a point which is was made in the evidence by Prakash, which was that really the ministry knew all about all of these separate storage areas. They were just historical, not being used, and the ministry knew about them anyway. He says at paragraph 9 of his statement, which is 1197, that prior to November 2012, the inspectors of the MEEA, the ministry that is, never inspected the area of the claimant service station behind the barricade, since it was assumed that no petroleum operations were being conducted behind the barricade. It was not until the ministry began to receive information about alleged illegal activities that it embarked on an enhanced inspection program, pursuant to which the inspectors carried out an inspection of the barricaded area of the claimant's service station. I mentioned earlier that there was, as my own friend Mr. Knox already mentioned, a request or an invitation to Mr. Prakash Maharaj to comment on the findings in the report, and that is repeated in a sense in the body of this affidavit at paragraph 30 on page 1202. Now that the minister has approved the report, the ministry shall invite comments and representations on this report from the claimant. My lord, that's all I wanted to highlight in particular in relation to Prakash. In relation to Adesh and the station at King's Wharf, I can pick that up perhaps most conveniently from volume 4. This was inspected, you'll recall, on the 1st of December 2012, so a few days after the inspection of the Faizabad station run by Prakash. And in volume 4, it's page 1531, where Mr. Ramdahin says various things in an affidavit filed on the 27th of November. He describes the visit starting at page 1534, made what he calls an impromptu visit to the King's Wharf station on the evening of the 1st of December at about 5 o'clock. He mentions who was there. Paragraph 14 at page 1535, he says the claimant arrived within 15 minutes of our arrival. Upon his arrival, he says, we told the claimant that we wished to conduct an inspection of all the storage areas of the service station. Upon being told the purpose of our visit, the claimant responded by telling us that he did not have the keys to the areas which stored the above-ground diesel tank and 2 additional rooms we expressed an interest in viewing. After being informed of our intention to use a bolt cutter to gain entry, the claimant produced the keys and opened up the areas required. And he goes on to describe in some detail what it is that they found in there. And I don't want to weary everybody with reading all of it out, but the gist of it is they found tanks in there. They found the tanks full of water. At paragraph 18, Mr. Ramdahin deposes that the claimant said the tanks were water tanks. On closer inspection, I observed, says Mr. Ramdahin, that both tanks had zinc fittings on them with a length of piping that connected both tanks, which said fittings appeared to have been recently cut and resting on the ground. The claimant stated at this point, says Mr. Ramdahin, that he was washing out the tanks because he knew the ministry would visit his service station following the discovery of illegal storage receptacles with fuel, which he had found at his brother Prakash's service station in Faizabad and at their family's private business at Twister's restaurant and bar. And he says that he found there was a strong smell of hydrocarbons, the floor was slippery, and essentially discovered that this was something that this was liquid that at least contained hydrocarbon, and says that he found, this is paragraph 21, that there was stuff on the ground, liquid on the ground, behind the building, and other drains nearby, he said, had a rainbow sheen, which resembled the sheen left after a hydrocarbon spillage. This led me to believe that someone had engaged in dumping of hydrocarbon or petroleum products to the back of the service station. There was also evidence of hydrocarbon stains on the galvanized sheets, which were pointed out to the claimant as evidence of that fact. And he goes on to say essentially that that was the conclusion that he drew, that that there had been hydrocarbon or petrol, in other words, or petrol products had simply been dumped to some extent on the ground and run off in a fashion which was clearly environmentally very unsatisfactory, at least. In the same statement, it's also, just before I leave it, necessary to mention what Mr. Randahin, who, as I say, is the Chief Mechanical Engineer, says by way of summary. Paragraph 44 on page 1542, he says, when we inspected the service station on the 1st of December 2012, we discovered that its condition posed grave and great risk of fire to safety and lives and had the potential to damage vehicles and other property. The defendant had to act urgently and suspend the operations of the said service station to prevent such risk, damage, and injury. And my lord, again, there's an investigation report into that service station, and we can see that in the same bundle at page 1392, I think. Sorry, yes, 1392, it is 1392. And again, I can take it from the executive summary, page 1395. Bottom of that page, the impromptu inspection resulted, says this report, in detecting unacceptable conditions and non-conformance, notably unauthorized storage tanks, questionable IBC receptacles. I think IBC is intermediate bulk container, large tank in other words, in inconspicuous storage rooms, previously unknown empty storage compartments on the outside area of the service station, visible evidence of an unknown hydrocarbon product on the floor and to the back of the service station that was apparently washed down with water, which when traced was identified as the cause of pollution sheen in the nearby marine environment. A confession, it is said by Mr. Maharaj, about washing out the unauthorized tanks on site. And he goes on to say strong stench of hydrocarbon vapors in the inconspicuously disguised and enclosed storage rooms was an imminent fire risk, which if allowed to manifest could have easily escalated to adjoining businesses. And again, there is reference to suspension of the operation of the service station pending further investigation. So, for present purposes, that's again all I want to take your lordships to in that context. And of course, in the same way as with the report in relation to Prakash, the request was then made. A request was then made for any comments about that that the recipient of the report might have, or rather that in that case Adesh might have about it. So that's just a brief flavour of the factual evidence on the ministry's side. I accept, of course, entirely that that there was equally evidence from Prakash and Adesh to say essentially that all of these concerns could be explained in ways that didn't involve any wrongdoing on their part. But that was the situation as regards the evidence that was before the court. You were shown, your lordships were shown this morning the way in which that was, way in which the argument was presented on behalf of the ministry. And it's right to say that there was, by the time of the hearing before the judge, the trial of the action before the judge, there was a focus by the ministry, amongst other things, but there was certainly a focus on the contention that actually there was no license at all because of the fact that all licenses had been stopped from being issued in one case, and in the other because in fact the license had never been transferred from the late father. But that wasn't quite the only thing that was said, and I just wanted in that context just to go back, or to take your lordships back, if I might, to the way in which the case was put in the arguments before the judge. My lord, that's in volume 5. So far as the case brought by Prakash is concerned, it starts at page 1609. And we can see at 1610, in fact, after the initial introductory paragraph, it launches straight into quite a long factual account of the ministry's case about the facts. It describes the inspection that I've just been reading out evidence about to your lordships, describes what is said to have been found, and describes the inspection, the report that we looked at, and indeed other reports that were commissioned at the time. When we get into the meat of the legal argument, it is, as I've already said, true to say that there is reference to the absence of a license. I can pick this up from 1615, paragraph 17, under the heading Discussion and Analysis at the bottom of that page. And it's quite right to say, as I think you were shown earlier today at 21, what is said is that the claimant is not the holder of a valid license to operate the service station, and that is expanded upon. But what is also said is what we can see at paragraph 25 on page 1618. Even if he had a legitimate expectation, which is not accepted and not claimed, that's to say an expectation of being treated as if he were licensed, contrary to the case then being run that he wasn't. That expectation, i.e. Prakash's expectation, can be frustrated in the public interest. So too, if he was treated as a licensee, that treatment can be stopped in the public interest. In this case, the evidence of the defendant shows that there is an overriding public interest which justifies the frustration of any expectation which the claimant may have had. We have shown above the evidence which speaks, the writer goes on, to the unsafe operations at the petrol station and to the sale of petrol products which did not meet the specifications and the risk to properties adjacent to the petrol station. We've also shown that these are matters that required the urgent action in the form of suspending the operations at the petrol station. Further, the defendant's intervention was reasonable and proportionate in all the circumstances. The ministry has a duty to protect the public interest, and it was necessary and reasonable for the service station to cease operations. That's as far as Prakash's case is concerned, my lord. We see the same pattern in relation to the case brought by Adesh. I can take this very quickly. I hope at 1627 we see the defendant's written submissions in answer to Adesh's case. Again, after the introductory words, they begin with a description of the facts as presented by the ministry, all of the various things that were found on the inspection, both of the King's Wharf and I think in relation to the compound as well. And then when we get into the legal argument, we have the same pattern. Again, this all starts here at, I think, around, it starts at page 1634, discussion and analysis, and again there's some stuff about the absence of a license. Various authorities are cited in relation to that. But just as in Prakash's case, there is also a case advanced on the facts. This is at page 1640, paragraph 39. Even assuming that he, Adesh that is, has a legitimate expectation, i.e. that he can carry on despite what is contended to be the absence of a license. And it's the same formulation that can be frustrated in the public interest. And we have shown above the evidence which speaks to the unsafe operations at the petrol station. And so on in exactly the same vein. So, my lord, that was the position as far as the factual evidence was concerned and the way it was put on the written submissions when the matter came before the judge. You've been shown what the judge said about the way in which the parties did not invite her ladyship to resolve factual disputes. The question then arises: well, what is the right approach? What should have been the right approach to dealing with this outstanding issue of fact? And I do respectfully submit that the formulation that we adopt must be the right one. It does, we submit, fall to be assumed for present purposes, without deciding it, of course, that the respondent is right to say, at the very least, that there were grounds to suspect the appellants of having been conducting petroleum operations illegally, dangerously, and in a manner which was potentially damaging to the environment. In other words, inimically to the public interest. And in my submission, the question is simply one of principle. On that basis, on that assumption, did the respondent have the powers to do what it did? Did it exercise those powers lawfully? my learned friend says, no, that's not right, and actually this was a pure question of law that arose. The trouble with that, my lord, I respectfully submit, is that you can't really have completely pure questions of law in any piece of litigation. There's got to be some assumption as to what the facts are, otherwise one has no idea what the basis is for engaging the law, beyond simply asserting what the text of the statute says, or what cases might have said in other cases. You need to have some presumed set of facts. Otherwise, there's no point in having the whole discussion at all. There would be no point in having this debate about what the powers were if the underlying assumption were that everything taking place at the service stations was A1 and all fine. So in my respectful submission, the alternative way of looking at it doesn't make sense, and the only sensible way to approach the matter is what were the respondent's powers on the assumption that these the facts were as the ministry alleged them to be. That the parties could, of course, have taken a different course. Judicial review is, of course, generally not a jurisdiction where the court finds facts, but there are exceptions to that, and the parties can, if they want, press even factual issues, and could have insisted upon there being a factual determination by the judge of whether the ministry had got it right or not. The claimants could have insisted upon that, could have sought directions for the trial of those issues. They didn't. They chose to take their stand on the issue of principle. But that, as I say, can only, I submit, logically be determined on the basis that the question they were really asking is if it's right that we did these things, or at any rate that there is good reason to suspect we did these things, have we been treated lawfully? So, my lord, in that context, can I then move on to the issues of law that arise in the circumstances? And our first, my first point is really to ask: is it right to say that there was no power to suspend or to revoke the licenses? Your lordships have already been shown the Petroleum Act. There are a couple of other provisions in it that I just wanted to flag up. First of all, section 6 is the provision I think I've referred to, but haven't actually shown your lordships, which talks about the basic rule that people are forbidden from engaging in petroleum operations. This is 2425. You've got the electronic bundle. So you're forbidden from undertaking any petroleum operations unless you first obtain a license as provided for in this act or the regulations. Section 12 of the Act says this, and this is at page 2427, section 12, subsection 1. Without prejudice to any other conditions upon which a license may be granted by the minister, it shall be a condition inserted in each license for the licensee to furnish the minister at such times and in such manner as the minister may require full information concerning his operations. Provision shall also be made for the inspection of the plant, operations, records and accounts of the licensee by persons authorized in that by the minister. So the Act actually requires it to be a condition of a license for there to be provision for inspection of the plant by the minister. My point about that is, of course, that rather assumes that there might be some reason for inspecting, and that if certain things are found on the inspection, there might be certain consequences. Section 17.1 we've already looked at, of course, which is the section that says what needs to be in a license. I respectfully submit is not a tenable construction of that section, or that subsection 17.1, that is to say. It's not a tenable construction to say it means anything other than a license shall contain, amongst other things, but it shall contain provision for its revocation in the case of the failure of a licensee to fulfill the obligations the licensee undertakes. Yes, my lord.
Why couldn't one read the words contain appropriate sanctions, including the revocation of the license, where the word appropriate governs sanctions, and the sanctions may include the revocation of the license? They're reading it in effect as contain appropriate sanctions, including as appropriate the revocation of the license.
My lord, because if that's what it meant, the draftsman would have adopted the formulation that your lordship has just come up with in my submission. On its plain reading, I say it means that it shall contain appropriate sanctions, which gives a degree of flexibility on the part of the grantor of the license, but it says the sanctions shall include the revocation of the license in case of a failure by the licensee to fulfill the obligation undertaken by him. In my submission, that's the more natural reading.
But these licenses typically will be given to private companies which are expected to invest in the petroleum infrastructure for Trinidad and Tobago, so including refineries, exploration pipes and things like that. And in effect, the impression I had from reading the Act was that one anticipates a commercial negotiation in effect between the third party provider of services and infrastructure and the Trinidadian government. And what is written into the license, including sanctions, will reflect that commercial negotiation. And against that background, again, why should, if you like, the freedom of negotiation between such parties be limited by adopting the interpretation of Section 17.1 that you're adopting, rather than leaving it open to the government to decide whether, in a particular context, it needs the sanction of revocation alongside other sanctions?
Well, my lord, one answer to that could be because of the context. This is not any commercial negotiation between the government and any private body for the purchase of some thing that the government needs. This is a context in which there are particular dangers. There's a particular reason for the legislature to have wished a fairly tight rein to be kept on the scope of the government to negotiate, to exercise the powers it would otherwise have to negotiate freely with private parties. And in that context, it makes sense that while the legislature says it should contain appropriate sanctions, leaving it up to the discretion of the government to decide what is appropriate in a particular case, it nevertheless says that those must include the revocation of the license in the case of the failure by the licensee, etc. I think that's about the best answer I can give to your lordship's question. So, my lord, that's section 17.1. You've seen section 17.2, and forgive me, yes, my lord.
Mr. On section 17.1, if there is a mandatory revocation, when is it exercisable? Is it exercisable any failure, any failure to comply with any obligation? It's very broad.
I accept, my lord. I accept it's broad, my lord. It would probably need to be coloured by section 17.2c, which refers to breaches of other terms and conditions contained in the licence in a material particular, the minister being the sole judge of such materiality. Parliament can't have intended that the compulsory sanction of revocation in case of a failure was applicable in the case of an immaterial failure to fulfil the obligations. Reading it as sensibly as one can in the context, in my submission, it ought to be read to say the material obligations or a significant failure. I accept that it wouldn't be right to say that every license must have a term that every failure, no matter how trivial, gives a right to revoke. It's one of a number of respects. Yes, my lord.
Looking at the point that the discussion you had on 17.1, is there a clue what the correct answer is in the first line of 17.2? The cases in which revocation of a license are to be provided.
I think there is, my lord. Your lordship is, with respect, right. That does.
Doesn't say may.
What that does first of all is make it less likely that section 17.1 means shall contain a sanction of revocation if it's appropriate.
Precisely.
Because I think that's your lordship's point. And I would but I'd also invoke that subsection in relation to what it says at paragraph C about materiality. My lords, I'm just pausing because there was I think, forgive me, my Lord Hodge had disappeared for a moment, but you've reappeared. So I was looking at section 17. There is also some stuff which is relevant in the regulations as well. And these I'm talking about the petroleum regulations. These are, as far as relevant for present purposes, at 2444.
Are you coming back to section 33 later on?
I'll deal with section 33 later on, my lord. Yes, I will.
Thank you.
Because it's a later on point. Regulation 42, as your lordships will see, or I can read out for anyone who can't see it. 42.1, a licensee shall perform, it's slightly oddly worded, shall perform such of the general obligations specified in sub-regulation 2 in his license. Probably ought to be read such of the obligations specified in sub-regulation 2 as are stated in his license, I suppose. But it goes on then to say a licensee shall, and there are various things that the licensee shall do, and letter B is carry out his operations with due diligence and act in accordance with sound petroleum industry practice in the conduct of all operations. And then skipping on a bit, it says at K, comply with all instructions issued from time to time by the minister that are reasonably necessary for securing the health, safety and welfare of persons employed for the purpose of operations. And L is enabling inspections to take place. And that obligation, particularly at letter B, to carry out the operation with due diligence and act in accordance with sound petroleum industry practice is important because I'll come back to it in a minute, but in the last iteration of the written license agreements, we do see a provision that requires compliance with the regulations. Finally, on these regulations, Regulation 43. Regulation 43 is mostly, as far as one can tell, about drilling for oil and refining oil, because of course, as your lordships will have picked up, the Petroleum Act doesn't just deal with people who sell the stuff right at the end of the process. It deals with the whole thing from when it comes out of the ground. But what is relevant in that context is that it says a licensee shall observe the following requirements where applicable, and then skipping through, we get eventually to letter S, which I've got on my page 2450. I'm sure lordships will have too. Take all reasonable precautions and safety measures to prevent the occurrence of blowout and fire. Well, blowout is obviously something different, but fire would seem applicable to a petrol station, to ensure that water resources are not damaged or contaminated by the escape of petroleum or other material used in the course of operations, etc., and strictly to observe directions from the minister. So that's the relevant, for this purpose, the relevant statutory context. If we can just go back to remind ourselves of the terms of the written license, that is in volume 1 at, I think, page 119. I think 120 is the one we've looked at, I think. Doesn't matter, they're the same. Condition 4, the licensee shall comply with the provisions of the Act and the regulations and any rules or orders made thereunder. The upshot of which, in my respectful submission, is that there was an obligation in the license, even on the original formally issued license. There was an obligation to carry out all operations in accordance with sound petroleum industry practice, because that was incorporated by reference to the regulations. So that's the statutory background. The short point we make, which I think your lordships already have in relation to the deemed license, is the point that if the ministry is to be stuck with an estoppel or perhaps a legitimate expectation that a license has been granted, or rather that the appellants are to be treated as if a license has been granted, then it can't be a license which is anything other than compliant with the statutory regime. And if I've persuaded the board that my construction of the statutory regime is right, then the upshot is that it is a license which contains a sanction for revocation for breach of any of the obligations, or any of the substantial obligations, material obligations that were undertaken. And the obligations that were undertaken include obligations as regards inspection, which implicitly involves the proposition that if something is found that is not as it ought to be, that can be put right in some way, and it involves obligations in relation to the safe operation and the operation in compliance with sound practice of the station. My lord, that's the first way in which we say, first of all, that there was a power of revocation in the licenses. The second way is in relation to is done by reference to rather the Interpretation Act, and your lordships were taken by my own friend this morning to the relevant passage of the Interpretation Act. It's the one which is at 2409. I accept, of course, that the Interpretation Act, as it says in itself, is subject to any special regime that is set up by any particular statute, a lex specialis. But I'll come back to that point in a second. But subject to that, in my respectful submission, the argument seeking to, as it were, get out of what I submit is the plain wording of section 45(3), specifically 45(3)(b, doesn't really work. This means essentially what it says, and where a written law confers power to grant a license, it includes the power to suspend and cancel such grant. And in my submission, those words should be given their full effect, and there is no reason for full effect subject to anything to the contrary in the specific regime one's looking at. Those should be given their full effect, and there's nothing in the wording of subsection 3 to lead one to think differently. The words after the semicolon, nothing in this paragraph shall affect, etc., are simply tailored to a particular situation where there is a right to appeal against a decision with respect to a grant. All it's intended there to say, I submit, is that if statute has conferred a right of appeal, for example, against the suspension or the revocation of a license, then the fact that the Act says what it does about the power to suspend or cancel doesn't deprive you of your right to appeal against that decision. It's really for the avoidance of doubt provision, in case anybody were to try and mount an argument that it had that effect. So I respectfully submit that, subject only to the point that, well, there's a special regime in the Act, that is another reason for concluding that there was a power to revoke, and indeed here a power to suspend as well. The point which is taken against us is well, look at section 17(6) of the Act. That, the lordships will recall, is the provision that says, in the case of serious and repeated violations of any of the terms and conditions of the license, of his license, or of any law or direction of the minister, the President may order such of the operations provided for in the license as he may think fit to be temporarily discontinued. I accept, of course, that there is a bit of an incongruity about the existence of that provision alongside a more general entitlement on the part of the minister to suspend. But in my submission, the principle that where there's special provision, one doesn't look at the generality, to summarize it that way, can't really bear the weight that's placed on it here. This is This is, as we've seen, a statute that deals with a whole range of different subjects within the field of the petroleum industry. It is, as I think I've said in the written case, it's very far from being a tightly drafted code. And that the task of construction that the board is embarked upon at the moment might superficially be thought to be the sort of task that you get if it's a contract that's been drafted by, after very careful thought, by very sophisticated commercial parties. But actually, when you start to look at the Act and the way in which it all fits together, it's not as tightly drafted as all of that. So it's the anomalous nature of this provision, or the incongruity, is not, in my submission, a sufficient reason for not giving effect to the provisions, to the rest of the provisions, which in my submission give the powers that I've referred to. I should perhaps just make clear how I, as it were, complete what I say under section 17(1). I've talked about how there is a power of revocation implicitly in the de facto licenses. What about a power to suspend? Well, my respectful submission is that once one establishes that there is a power of revocation, then by necessary implication, there must be a lesser power or a power to do something which is less draconian, namely to suspend. My learned friend points out that the authority that we rely upon in that context, the Leicester Gaming Club case, which the Lordships will recall is the case that says that where an express power exists, the question whether there is an implied power is dependent on whether it's reasonably incidental to the existence of the express power. My friend points out that is a case, or at least the case of which it's based. We took it from a more modern case, but the 19th century authority on which it's based is indeed a case about capacity. The capacity, I think, of a local authority to do something or not to do it. And I accept we're in slightly different territory here, because we're not talking about the capacity of the minister. But the fundamental point in my submission is unaltered by that distinction. In other words, it's that distinction is not a material distinction. The same proposition in my submission is right. My Lord.
Yes, thank you. Just on the question whether power to revoke must include a power to suspend, I wonder about that, because if one looks at section 18, where there's a revocation, there's a specific remedial regime which is brought into effect, which wouldn't apply in relation to a suspension. So the impression one gets, and I'd like your comment on it, is that actually revocation does mean revocation, and there's a particular remedial regime in relation to that, which would make it difficult to spell out an implied power of suspension where there's no equivalent remedial regime.
Well, my Lord, the fact that there is a specific remedial regime in relation to revocation perhaps reflects the fact that a revocation is at least generally going to be a very much more significant event for the licensee than a suspension. But the fact that that regime exists doesn't, in my submission, mean that one cannot imply into the overall regime a power to suspend. And in my submission, the context, the facts, or the assumed facts, as I contend that they ought to be in this case, illustrate precisely why power to suspend is necessary. It can't, in my submission, be a sensible construction of the Act. And it certainly isn't a construction of the Act that one should reach unless one is absolutely driven to it by the wording, that no matter what the minister may think is going on at a petrol filling station, no matter how dangerous it is, no matter how unlawful it is, no matter how damaging to the environment it is, nothing can be done about it short of revocation. In my submission, that would be stepping back from the detail. That would be a very odd state of affairs in the law. And so while I accept that one can always point to certain provisions and say, well, it's a bit anomalous for there to be this power when the Act says something else in different contexts about revocation. In my submission, if one starts from the basic proposition that one would expect there to be a power to suspend, simply because that's what the public interest surely must require, then in my submission, points like that point about section 18 don't really detract significantly from the force of that point. I of course, I see the point, but as I say, the distinction is revocation is the complete removal of a license, of course, and it doesn't just affect people in the retail sector. It could include revocation of some right to drill, which would have an enormous consequence for lots and lots of people. So it's not surprising that that has a particular remedy attached to it, or a particular regime attached to it for anybody who wants to complain about it. But in my submission, that doesn't detract from the point that we make about the importance of a power of suspension. So, my Lord, for those reasons, essentially, we do. I see that my Lord Briggs has a question. I don't think Your Lordship's microphone is yet on.
Forgive me, I think it is on now.
Yes.
I jumped the gun. Is a possible alternative explanation of the suspension problem that if, as you say, suspension is a sort of half-hearted or is contained within a power to revoke because it's a lesser exercise, then maybe it's contained within section 18 as well. I appreciate it that you wouldn't get there via the Interpretation Act, but if you say that a power to suspend is a sort of partial exercise of a power to revoke in section 17(1)(c), then it would fall naturally within section 18(1). It's difficult to see an awful lot of difference between a suspension until the last day of a one-year license and a revocation of it.
Well, my Lord, yes, I see Your Lordship's point, and certainly if one construes a suspension as in a way a species of revocation, then it must naturally follow that section 18 is applicable. I do see that. So, my Lord, those were the grounds really upon which we submit that there is, by virtue of the working of the Act on its own and or with the aid of the Interpretation Act, a power to suspend. The other thing I wanted to deal with briefly was section 31, which Your Lordships won't find in the record, but which is in the version that was sent earlier on. So I hope Your Lordship has it. Forgive me, section 33 rather, of the Act. And what I say about this must to some extent be slightly provisional, because I think in common with everybody else involved in the case all the way through, have been working off a copy of the Act, which certainly as per the record doesn't go beyond section 30. And it was only as it happens, because I had a technical problem this morning with accessing my copy of the record, that I went to look at the full, well, I look at the thing online, which turned out to have more sections than had been there in the record. But section 33, which doesn't appear, I don't think anybody thinks it's been mentioned before, doesn't appear to have been mentioned before, talks about revocation. As Your Lordships will see, what it says is, except as may be otherwise provided for by the license. Any permission, consent, or authority granted under this Act and the regulations, or any rules or orders made thereunder, A, may be either general or specific, B, may be revoked or varied by the Minister. So that would appear to give a specific power of revocation, unless the license explicitly says that it is not to be revoked.
Yes, it seems to draw a distinction between the license itself and then permissions, consents, or authorities. Can you help us with that? Because it's talking, when it says something may be revoked, it's a permission, consent, or authority rather than the license.
My Lord, I can see that that's a possible construction of it. I'm not sure I can add much to that observation. Your Lordship, that may be right, but equally on an ordinary reading of the language, although I agree it distinguishes between, although it mentions license in the context of the exception, anything in the license can provide otherwise, nevertheless, that's for that clause at the beginning is for the purpose of of accepting what's expressly said in the license. It doesn't necessarily follow that the fact that it's worded that way is intended to mean that a permission, a consent, or an authority cannot consist of a license itself, because after all, what is a license but a permission or a consent or an authority? That's about, I think, about as far as I can take that.
Thank you.
So, my lord, in those circumstances, I respectfully submit that there was here a power both to revoke the license, though it is not, I emphasize, the respondent's case that is what happened, and to suspend the operation of the stations in circumstances where it was justified to do so. And the question then arises, of course, what were the circumstances in which it was justified to do so? Well, plainly, if the suspicions that the minister had were anyway reasonable suspicions, this is a very clear case on the facts. Again, I accept, of course, that there is a factual dispute, but as I've said, the claimants did not invite the court to resolve that factual dispute in their favour. They were content to go into the trial of the judicial review on the basis that it was really a question of law. And as I say, that I submit that it requires to be determined on the assumption that the minister is right about the facts, or at any rate, the minister has got decent grounds for suspecting that he is right about the facts. And in those circumstances, what the minister suspected and had evidence of was a very serious breach of the terms of the license. It's true, of course, the license is pretty laconic about what the terms are, because it only contains a few, but as I've sought to demonstrate, it does contain, in fact, expressly, albeit by reference, because it's by reference to the regulations, requirements to conduct things in a safe manner and in a manner which is consistent with sound practice in the industry. And whatever else one can say about the case, it's pretty clear that on the minister's version of events, that was certainly not taking place. There was an awful lot of extraordinarily irregular activity taking place. It is said by my learned friend, that the minister didn't offer to prove that this had taken place, but that really just goes back to my point about the way in which the case fell to be determined. The parties could have, and the claimant in particular, could have invited the court to make factual findings. This is all nonsense, what the minister is saying. I've acted perfectly properly, but did not choose to do so. Instead, chose to proceed on the basis that the minister did not have in law the power. Staked everything essentially on the legal point, rather than accepting that there was the power, or provisionally accepting that there was the power, and inviting the court, therefore, to say that the minister was simply wrong as a matter of fact. What then about the question of fairness? We accept, of course, that the power, as we contend it to be, to suspend has to be exercised in a manner which is lawful in public law terms. It's amenable to review on all the usual grounds that the decisions of ministers are reviewable in the courts. But is it right to say that it was dealt with unfairly? One of the difficulties in this context is the way in which it was dealt with in the court below. Can I just take your lordships to that? If we go in the fifth volume of the bundle of the record, rather, to 1743, this is in the judgment of Madam Justice Gobin. Her Ladyship deals with the subject of procedural unfairness in the context of denial of legitimate expectation. And she starts out by saying essentially that there was making a point referring to a point that was being made by the claimants, which hasn't perhaps been the focus of my learned friend's submissions, that there was a legitimate expectation that, as she puts it at the bottom, there was a practice of issuing reports which indicated any breaches and unsatisfactory conditions existing at the claimant station over several years. And the gist of the point was to say, well, over the years, you've inspected from time to time, and when you've found things that are not to your liking, you've written to me and said, please put it right. In fact, your lordships were shown something of that nature from the Fire Authority at an earlier stage. And the point still seems to be being made at first instance that was applicable in the present circumstances. Well, in my respectful submission, that can't really sensibly be right. And that's one of the reasons I took your lordships to the nature of the evidence that the minister was advancing. It cannot be right in circumstances where there is seriously unlawful activity taking place, if the minister is right about that, and perhaps more pertinently, seriously dangerous activity taking place, dangerous and or environmentally damaging activity taking place, to say, well, the minister was bound because of previous practice to do no more than to write saying, would you mind putting that right, please, within 90 days or any period of time. It must be right that the minister had a power. If the minister has got a power to suspend straight away, the minister was able to do that. I skipped out, incidentally, I shouldn't have done in my submissions earlier, response briefly to the point, well, couldn't the minister have gone off to court either under this contract or instead of going off to court himself, have encouraged somebody else, like the fire authority under one piece of legislation or the environmental authorities under another? My lord, the short answer to that point is I respectfully submit that there is nothing in the regime to say that it is necessary for there to be an intermediate step of the court taking them in turn, going to court under the terms of the contract itself or the act itself to get an injunction. In my submission, that's plainly insufficient. If one's talking here about contexts where what's being done is dangerous, it can't, in my submission, be right to say that the minister's power is limited to seeing whether he can track down a High Court judge and get an injunction on quickly enough to have the matter stopped. Nor, in my submission, is it a good point at all to say, oh, well, that would have meant if it had been done that way, everything was under the control of the court. This is, in my respectful submission, a paradigm example of a field where it is important that the executive, which in this case has the expertise to carry out the inspections through its technical officers and to decide what ought to be done, should be allowed to get on with doing that, subject only to ordinary grounds of judicial review. So in my submission, it's not appropriate to say there should have been an application to the court. And the fact that in relation to discrete other aspects like fire or the environment, there were other powers that other agencies had to apply to court for other remedies is, in my submission, neither here nor there. But my lord, that was just to pick up on something I missed out earlier on. But in relation to the question of whether the respondent acted fairly, I was just showing Your Lordship the way in which it was dealt with by the judge, and as I've explained or sought to explain, the judge looked at it initially in terms of the supposed expectation that essentially whatever happened would only be met in the first instance by a request to put it right or a demand to put it right. Over the page at 1744, the learned judge goes on to say that the minister's response is disappointing. The ministry had said that it was insufficient in law to establish a settled practice. I submit the ministry is obviously quite right about that. And then at the bottom of that page, the defendants, paragraph 72, the defendants say, however, that even if the claimants were entitled to the benefit of the notice and time for corrective measures under a settled practice, the exigencies of the situation required urgent action, and that this sufficiently justified their actions and trumped any entitlement to the procedural benefit of the practice regarding notices. While it may be the case, and it is settled, that in situations which require urgent steps to preserve the welfare of citizens' health, safety, and the environment, a body may, in the exercise of it, and she's quoting here from another authority, in the exercise of its lawful power, override the established obligations to give the party effective an opportunity to be heard. These are not such cases. I have found that the ministry was not exercising a lawful power conferred by the Act or agreed by the terms of the licenses. In the circumstances, the case of which is what I just quoted those words from, is inapplicable. My lord, the problem with that is that, of course, at this point in the argument, ex hypothesi, the ministry is exercising a lawful power. This was a further aspect of the appellant's arguments. They were saying, well, you haven't got the power, but even if you did have the power, you exercise it unfairly. So one can't analyse that latter argument by going back and saying, well, you can't have exercised it unfairly because you never had the power. It just confuses, with great respect, the two different issues. And so, in my respectful submission, that doesn't assist at all. 73 then goes on to say that there's been no reliance on a power to override the legitimate expectation of notice where there's suspicion of a commission of a criminal offence. So again, the learned judge is reverting to her rejection of the, or reverting to her view that there was a legitimate expectation of notice, having rejected the contention that there might be circumstances where notice wasn't required, but as I say, on a wrong basis. She says the absence of the police involvement makes a difference. What is noticeably absent, she says, towards the bottom of that paragraph in the case for the ministry is the evidence of active police involvement in the matter. In any circumstances of the closure for 20 months without charge, the delay hardly seems justifiable by any standard. This, to my mind, points to the unreasonableness of the decision, but in the light of my other findings, I do not consider it necessary to deal with this further. And then she moves on to deal with the damages. The upshot is, my lord, that we don't have, in this case, any first instance finding, I submit, as to whether the ministry acted fairly or not. The only hint of what the learned judge considered on this point is the reference to the period of delay. But in my respectful submission, that is not a matter where there was really any sound basis, nor would there be now any sound basis for the board, if it accepts that my point that there was no real finding at first instance. There's no sound basis for the board now to say, well, actually, in the circumstances, this was unfair. There is no evidence as to how long the investigation that the ministry undertook ought to have taken. The short way to describe this, in my respectful submission, is simply this. This was a case where the ministry exercised its right to inspect, having discovered what it discovered in the case of both stations on the exercise of that right to inspect. It exercised the power which ex hypothesi for this part of the argument it had to suspend the operations. It then conducted an investigation. Having conducted the investigation, it invited submissions from the persons concerned. But in the meantime, what had happened is that the claimants had taken a different course. They had gone into court saying, essentially, we want an order of mandamus to have our stations back, our licenses back, on the footing that you have no power to do any of this. Well, my lord, in my submission, if they're right about the first point and there was no power, then they succeed. But if they're wrong about that, then the fairness argument, in my submission, doesn't work, because it simply involves the court getting into territory which it's just not given the tools to get into, namely, what was the procedurally fair way? What was the fair way in which this should have been done? And once it's accepted that there was an opportunity provided for comment to be given on those reports, which set out what it was that the ministry had found, then really the only complaint is, and my learned friend alluded to this morning, is really about the time it took to get to that process, and the fact that during the course of that, the licenses in fact elapsed, or the deemed licenses elapsed, or by a fraction of time. But that complaint of delay, in my submission, doesn't give rise to any cause of action in the present context. So sometimes, of course, one comes across cases where the public authority has to take a decision, and it takes so long to take it that the people waiting for it bring an action saying the delay in itself is unreasonable. That itself is a public law wrong, and they seek an order from the court that a decision be taken within a reasonable time. None of that was done here. The claimants decided to stake everything on saying that there was really no power to do any of this. And in those circumstances, in my submission, it isn't appropriate to seek to rescue the matter by reference to considerations of delay. Well, these arguments were briefly dealt with in the Court of Appeal, and I should just remind your lordships what the Court of Appeal said about it. So far as the majority were concerned, they were not prepared to say that there was any procedural unfairness, and that we can find in the judgment in the record at page 1959. It starts in 1958, really. Discussion. 55, I have considered the approach of the minority on this issue. I should say this is the learned Chief Justice speaking. Insofar as what was reasonable and proportionate in the circumstances, it appears to be based on the assumption that most of the breaches complained of were remediable within an ascertainable and certain time frame. In my respectful view, there are two flaws in that approach. Firstly, we're not told what the time frame is, so that begs the question of whether the potential threat to public safety as a matter of proportionality is overridden. Secondly, and in any event, there is no evidence that the alleged breaches were remediable before the expiration of the then current licenses, which were subject to annual renewal. Permitting the respondents to continue operation until the expiration of their then current licenses would effectively negate the Ministry's acknowledged power to intervene in the public interest. So that's really what they say, and it's true, of course, to say that the minority, Justice Appeal Jamandar, took a different view, and Your Lordship can see that at 1973. Paragraph 19, the fundamental issue is the title of this section. Therefore, the fundamental issue in these appeals reduces itself to the question, what fair, reasonable and proportionate opportunities were given to the respondents as the holders of valid and enforceable licenses to remedy alleged concerns and gaps in operational process structures, policies and standards, and to address institutional integrity and reputation, all of which could have potentially been remedied on the available evidence within fixed timeframes if necessary, once sufficient particularity of gaps, standards and expectations were identified. And the learned Justice Appeal goes on to say, to suspend all activities in circumstances which effectively denied the respondents any effective opportunity to address the cited concerns was, in my opinion, unfair, unreasonable, arbitrary and disproportionate. Suspension of activities with approximate, accompanying and reasonable opportunity to explain and or address and remedy the stated complaints properly particularized is what would have been fair, reasonable and proportionate in the circumstances of these appeals. Such a course, the means, would have satisfied the articulated and legitimate concerns for public and facility safety, product and quality and integrity and institutional reputation, the aims. Such a course would also have been helpfully pragmatic and aligned with the Ministry's claimed duties and responsibilities. It would have struck a fair balance between duty and opportunity. My Lord, in my respectful submission, the majority got this part of the case right. There was, I respectfully submit, no proper basis on the evidence to reach that conclusion that was reached by Justice of Appeal Jamandar. As I respectfully submit, what the evidence in fact shows is simply that their ministry, and I'm conscious I'm repeating a point, so I'll do it no more than briefly, the ministry found what it found, and if it has the power, if it had the power to suspend, then it lawfully exercised the power to suspend. The only question is whether, in those circumstances, the delay in conducting the investigations and then putting them to the claimants was an unreasonable delay in all circumstances. That would have required a detailed factual inquiry into what level of delay was reasonable. How long does a reasonable petroleum authority take to conduct investigations into matters of this nature? None of that was before the court, in my respectful submission. And rather by the same token, in my respectful submission, there was no proper basis for the learned judge's contention that, well, this was a revocation. You may recall, my lord, that you were taken to the learned judge's judgment where she says that in substance this was a revocation, and that's what the ministry intended to do. My lord, in my respectful submission, there's no reasonable basis for that finding, so it's not insulated as a finding of fact in the way that some findings of fact are on an appeal, let alone a second appeal like the present one. In my submission, there was simply no basis for the learned judge to deal with the matter in that way. What the evidence in fact shows, as I've said, is simply that there was a suspension pending these investigations which were carried out. And there's no basis for the judge putting the matter in the way that the judge did. Well, I think I've dealt with more or less everything I want to deal with under that aspect of the case. there's one final point I should mention before I leave altogether, and that is, what about the fact that the ministry was saying by the time the matter got to court, oh, well, you have no license. Does that mean that by that point there became a revocation? Well, part of the difficulty with the argument that there was a revocation is the difficulty that was highlighted by, I think it was Lord Hamblин's question this morning. When did the revocation take place? Unless one can say that, then it becomes difficult to say that there was a revocation. And what that question and the difficulty in answering it illustrates, in my submission, is really that there wasn't a revocation at all. It's true that what had happened by the time the matter got to court was that the ministry had highlighted, or had alighted upon, I should say, a point about the absence of any license, and it put that as the front of its submissions. It said, well, this is all, essentially it was saying, well, this is all very interesting, but the fact is these people never had licenses anyway. But it doesn't follow from that, in my respectful submission, that you can convert what is self-evidently a suspension with reasons for the suspension and an opportunity provided to the suspended persons to comment as to whether the reasons are good ones, into a revocation. My submission, that just doesn't work. And so there's nothing in that point. If the board is against us in relation to all of that, and so there has been an unlawful suspension or revocation of the licenses, does it matter that no applications were made to renew the licenses while the proceedings were on foot? Well, in my submission, it matters very much. My learned friend says, well, it doesn't matter because by the time the licenses came to expire by a fluxion of time, there was an application before the court for mandamus. But nevertheless, these were annual licenses. The contention that the claimants were making was that the revocation of the licenses, as they characterize it, or the suspension of the licenses, was unlawful. So from their perspective, they remained licensees under the Act. And they knew, of course, that those licenses were licenses which expired at the end of the relevant period in each case. They essentially, again, by staking everything on the way they put the case, they essentially took the risk that, for whatever reason, mandamus might not come to be granted, mandamus to restore them to the position they were in, by which point the licenses would have expired. So in my respectful submission, the license is expired, and that is that, so far as any contention based upon damages being awarded for any period beyond that is concerned. The license is simply expired, and one can't ignore that fact, because of course the purpose of this part of the appellant submissions is to say, well, if we've succeeded this far, if we've established that we have a claim for the unlawful deprivation of our licenses, then when the court comes to assess damages, it should assume that the deprivation continued for a long period. But it would be quite contrary to principle, in my respectful submission, for the board to ignore the fact that the license was A, only a license for a limited period, and B, not sought to be renewed. The appellants did not seek to renew them. They didn't. Neither, indeed, did they seek to do what they had done historically, accepting, as we now do, that there was a de facto position prevailing, which didn't actually involve the formal granting of licenses. They didn't do what they'd done historically, which was to pay the fees for the renewal of the licenses. So in my submission, any claim for damages, however it's put, can't last beyond the date on which the license expired. Well, so far as damages are concerned, I can take this, I hope, fairly briefly. In relation to the claim by reference to the arbitration provisions of the statute, your lordships were taken through those this morning. I won't go through them again. What we can see from them is a fairly detailed, worked out procedure by which, starting, I think, with section 18, somebody who complains of the revocation of a license or the termination of a license can get the matter to arbitration, and an arbitrator or arbitrators can make an award of reparation. And the short point that we respectfully make about that is that that is the route map which the legislature has provided to get to the outcome of reparation under the Act. It doesn't follow from that that in circumstances where the claimant decides not to avail himself or herself of that route, but instead to bring a claim in the court for judicial review, nevertheless, you can just have the same remedy. Why would it? Parliament hasn't provided that. Parliament's said, if you want this, this is what you do. And if you don't do that, it follows that you don't get it. So in my submission, that just doesn't work. The last point is under the Constitution. I accept on the basis of Paponet that a license can constitute property for the purposes of the constitutional provisions about deprivation of property. I think in this context, I am probably driven to do what the judge did in relation to the legitimate expectation argument and say, well, we don't accept the premise. We don't accept the premise that there was an unlawful revocation of the license. In relation to Lord Sales's point about the property, my lord, I submit that the better analysis is the way that the appellant advances it. That if there is to be any deprivation here, it's not a deprivation of the property in the sense of the physical space upon which the station is located, because that space was not taken away from the appellants by the respondent. What the respondent took away was the ability to use that space to do what they had previously wanted to do on it. And that, if anything, is the issue. But, my lord, for the reasons I've sought to outline, and for the reasons indicated in our case, I see. Lord Sales has a question. Yes, my lord.
Yes, it was really saying, I mean, on the basis of accepting the licenses property, I don't think we need to get into any more rarefied analysis under Section 4 of the Constitution. But can I ask you this? I understand that you say you don't accept there's an unlawful revocation. If there's not an unlawful revocation, but we conclude an unlawful suspension, would you accept that damages would be due for practical loss of the license during the period of the unlawful suspension?
My lord, I would submit that falls short of a deprivation of property, because the premise of a finding like that is that the license subsists, or subsisted at any rate until it expired by a fluxion of time. The appellant's doing nothing to seek to renew it. But that's different from having it from a full-scale deprivation. One needs to construe. I mean, clearly, one needs to construe these constitutional provisions with a degree of broadness and generosity in line with all of the authorities. But in my submission, it's not broad enough to say that a mere suspension, even if unlawful, constitutes a deprivation. The way one can test that by supposing that what had happened is that there had been a suspension for a while, and that after a bit they had the suspension, perhaps because suppose that the litigation process had been telescoped into a much, or compressed it rather into a much quicker period, so that we were now only a few months away from, only a few months after the date in which the operations had been stopped. So the position was they were still there, ready to go as soon as the court decided, if it did so decide, that they were entitled to carry on because the suspension was unlawful. Could it be said in those circumstances, well, what's happened here is deprivation of property? In my submission, probably not. You would just say, well, yes, my lord. I don't think your microphone is on yet, my lord.
The right conferred in 4A is, a reading short, a right of the individual to enjoyment of property and the right not to be deprived thereof except by due process of law. Now, certainly in Strasbourg jurisprudence, deprivation of property without compensation is a wrong. Interference with enjoyment isn't necessarily a wrong if it's lawful. But here the hypothesis is that the interference is unlawful. Does that affect your argument?
Well, it affects it, but it's not necessarily a fatal blow to it, because in my submission, it can't be right that every, well, I submit it can't be right that every unlawfulness that occurs in relation to person's entitlement to use their property for a particular purpose automatically results, or is automatically and always to be interpreted as a breach of the Constitution. That can't be right in my submission. That would be to conflate mere unlawfulness in a public law sense with an infringement of a fundamental right under the Constitution.
Yes, but if here we are dealing with a suspension which lasted a considerable time, and we're told, I think, by the claimants that in one case went on, I think in Prakash's case, in effect, went on to May 2014. It is tantamount to a deprivation of property. Because the thing itself ceased to exist at the end of that period.
Well, again, it depends on exactly what the premise is. It's true that the thing itself ceased to exist, but in fact, we submit the thing itself ceased to exist because of the failure to renew it during a period when it was suspended. I mean, I can see why it might be said against me if your lordships come to the conclusion that actually, essentially, this was a revocation and it was unlawful, so that in substance it comes to the position that there has been simply a taking away of the license without any lawful basis for doing so, then that puts things in a rather different light. But if I'm right that this was a suspension, then even if the suspension was unlawful, I mean, obviously it depends, I suppose, on precisely the circumstances in which and the extent to which it was unlawful, if one can put it that way, so how it was unlawful. But the mere fact that it was unlawful, if it was, doesn't, in my respectful submission, mean that this was a deprivation of property for the purposes of the Constitution. Your lordship's reference to the Strasbourg case law rather makes me think, my lord, that this might be an occasion where your lordships might be invited to consider something briefly in writing after today, while you're considering your judgments, because I don't want to be, I don't particularly want to be asserting propositions about Strasbourg case law entirely on the hoof and from memory.
Yeah, well, I was relying on memory too, because I had a case where a fish farmer was deprived of his salmon stock for health reasons, and it was Luxembourg said this wasn't a deprivation of property; it was a mere interference.
Yes, well,
so you welcome a written submission from you.
Thank you, my lord. My lord, I think, unless there's anything that your lordships think that I ought to have dealt with that I have not, that is probably all I need to say.
Mr. Rowe, thank you very much indeed for your very succinct and clear submissions.
Thank you, Lord.
So, Mr. Knox.
Hello, can you hear me? Yes.
Yes.
My lords, can I just deal with a few points on the facts first? There was no evidence whatsoever from NP to contradict what my client said about the extent and nature of the investigations over the years. Absolutely none from NP. And his case was that NP came around regularly. They knew perfectly well what the position was. Secondly, there was no evidence from the ministry, no proper evidence from the ministry to contradict my client's assertions about the nature of the inspections and investigation over the years. My learned friend drew your attention to Mr. Ramdahan's affidavit at page 11, volume 3, page 1197, paragraph 9, where he says what the ministry, what he he says the ministry's position is. He gives no grounds for that belief, either in paragraph 9 or paragraph 3, which is at page 1196, where he introduces the matter. There's no, you cannot proceed on this assumption. There was what you might call a clear dispute on, in fact, one of the fundamental points. Thirdly, no criminal charges were ever brought, although that actually was what the investigation seemed to envisage, certainly in relation to Prakash. Fourthly, for whatever reason, the minister never actually did issue a formal revelation. Fifthly, the fire service went round to Prakash's premises on the 29th of November, and they were, if I can use this phrase, they were unfazed. They said, "Well, you just need to you'll get things right within 3 months." And the reference for that is at volume 1, which is 244 to 246. The report is dated 26th of November, but in fact, according to the evidence, this is in the chronology, it was actually the investigation was done on the 29th, after history first went. Just dealing briefly with one or two other points. My learned friend referred you to a number of the witnesses. Suffice to say, every single one was rebutted in detail, not just by a sort of general denial, but in laborious detail by my clients. If I can just give the reference. Mr. Danoon, his evidence was disputed by Prakash, volume 2, page 499, paragraph 8 to page 501. Mr. Ramdahin's first affidavit, paragraph 30 onwards, was denied in detail by Prakash, volume 2, page 504, paragraph 11, 512, paragraph 1143. On the samples, my lord, the samples are, I don't want to say interesting part of the case, but actually the evidence of the samples was very damaging to the minister's case. If I can just briefly summarize, on the 16th of April 2013, there was a report. There were 3 reports provided. The first report, I can give you the reference, the first report compared a known condensate sample somewhere else with 2 of the samples taken on the 28th of November, Prakash's premises. The idea being, of course, to prove that the sample from Prakash's premises was condensate. Lo and behold, the expert said, no, it's a different substance. And the reference to that is at volume 1, page 360. It continued to say that the 2 samples taken from Prakash's station on the 28th of November were not petroleum. That was common ground, because he said exactly that they weren't petroleum. They consisted of sludge, which was piped up, pumped up through the pipes to the barrels. The second report, which is at volume 1, page 351. Volume 1, page 351. Referred to at 351.84 and 351.85. My lords, the evidence in relation to the samples taken from the storage tanks which serve the petrol pumps, there was nothing wrong with the diesel sample. You can get that from page 351 at paragraph 84. There was nothing wrong with the super sample, and you get that from page 351.85, and also 379 and 381. The only thing that they did find was that the premium sample was just below the relevant motor octane number, and I think it's RON, whose name, the meaning of which escapes me for the moment, but very slightly below. And Prakash explained that the reason for that is that water tends to leak down from his premises into the relevant tanks. So this is not a case where what you might call there was clear independent evidence which showed that Prakash was lying. On the contrary, this evidence showed that he was not putting bad oil or bad petrol into the storage tanks. Because if he had been doing that, they'd have come up on the samples, which were taken from the underground storage. Thirdly, in relation to the notice of non-compliance, Prakash answered that in detail in volume 1 at page 23 to 27. Mr. Ramdahin's report and Mr. Ramdahin's affidavit exhibiting the investigation report, he contradicts, again in considerable detail, in volume 3, page 1215, paragraph 5, to 1218, paragraph 5, and at 3, 1221, J to K. As far as Adesh is concerned, he denied the points in the notice of non-compliance, again in some detail, volume 4, page 1344 to 1349. And likewise, he disputed Mr. Ramdahin's later report in November 2013, and at the references volume 4, page 1546, paragraph 3, to 1562, paragraph 3, and 1562, paragraph 4, related to the report. So, my lords, I'm anxious to make this point because sometimes a court is asked to deal with a point on the basis of it makes certain assumptions, but we all know perfectly well that they're rather generous assumptions. It's anything but in this case. This is a case where there was a very serious dispute on the facts. My lords, that leads to my next point, which is namely suspension, and what is the premise on which the court should operate. My lords, it may not matter very much in the end, but in my submission, the premise on which you should operate is that which the judge sets out in the passage I took you in paragraph 62 of page 1740. The court hasn't had to make any findings one way or the other as to whether the grounds were well-founded or not. That, in my submission, is the basis. I submit there's no difficulty in proceeding on the basis. You can proceed on the basis that we don't know what the position is, but we are being invited to consider a pure question of law, namely, did the minister have a power to suspend? Or I should say this, it may not matter very much. The reason I say it is this. I think, as I understand my learned friend, he accepts that the most that the court can assume is that the minister had grounds to suspect. He does not invite the court to say that the minister's grounds were correct. And that is a fundamental point in the case. Because, of course, if the minister's grounds were correct, then I'd be in some difficulty in saying that there was no power to revoke, if there was a power to revoke. And if, in fact, if in fact my clients were operating very dangerous premises and had been found to be operating very dangerous premises in breach of the terms of the license, well, my lords, the whole question would have evaporated a long time. So we are simply at the moment that the only thing you can assume at most is that the minister had grounds, or maybe even reasonable grounds, to suspect. That, in my submission, does not make any difference to the ultimate question. That is whether or not there was a power of the minister's own motion to suspend. My lords, can I just deal, before I go to the license, before I go to the relevant part of the law, my lords, my learned friend says it's a de facto license. In my submission, that's not right. If you look at Regulation 24, of the regulation, I think it's at page 2443. I submit some, you'll see, if a license is not executed within 180 days of the approval of the application, the right of the applicant to such license shall be deemed to have lapsed unless the delay is not due to the fault of the applicant. In my submission, the converse necessarily follows, namely, the applicant has a right to the license. And if it's not his fault, the minister can't turn around and say, oh, I'm terribly sorry, old chap, you've just got one of those de facto licenses. In my submission, he has a right to the license if it's not his. All that can be said against him is that he hasn't got a paper license. But in my submission, that doesn't actually affect the nature of the license he has. Now, it may not matter very much because for the reasons I've already accepted, it may be difficult for me to say there's absolutely no power. I accept that it may be the license must contain at least a sanction because of the wording of section 17. I do submit that you cannot proceed on the basis this is somehow some sort of watered down license. It's a matter of right. My lords, dealing with suspension, my learned friend, I submit correctly and inevitably said, and this I submit should be the starting, is that there is an incongruity in implying a power of undefined extent for the minister to suspend, given the specific power that is conferred on the president in section 17.6. My submission, really, that is the answer to the case. My learned friend then says, but surely, if there is a power to revoke, come to that. But if there is a power to revoke, the greater includes the lesser. Well, in my submission, that's not right. First of all, revocation under the Act requires proof of breach. It is one thing to say I can revoke on proof of breach. It is a total non sequitur, in my respectful submission to say, and it follows from that there's an implied power to suspend without proof of breach. That can't be right. The very furthest it might be to say, if I've got a power to revoke on proof of breach, I can suspend on proof of breach. But you can't go that extra hurdle that Mr. Rowe invites you to go. I submit, in a sense, that's the heart of the case. That's the real difficulty the minister faces. He's asking you to infer just one thing too many from a power to revoke, if the power exists. My lords, I respectfully submit that is in particular the case, given that the president's power is upon proof breaches, not just suspicion. In section 17. My Lord Briggs, my Lord Sales pointed out that there was a specific regime for revocation in section 18, but no equivalent regime for suspension. And in my submission, that is a good point. And the only way, so to speak, out of that, Lord Briggs' suggestion that, well, perhaps you could read power of revocation as including a power of suspension. But if that is right, you run into the same problem, namely, the power of suspension can only be exercised upon proof of breach if it is subject to the same regime as the power of revocation. And my lords, can I just make this point? I mean, it's a fairly obvious point, but just draw the obvious analogy with common law, with contracts. If there is a reputed breach of contract, I can terminate, but there's certainly no implied power to suspend performance. On the contrary. So I respectfully submit that suspension and revocation are different things. You can't jump from one to the other. Just like dealing, if I may now, with the regulation 17.2, the power to revoke. My learned friend, my learned friend, and I think Lord Hodge pointed out, the important word in section 17.2 is the word are to be. The implication being, in other words, are to be meaning must be. And also, the only problem with that is with section 17.2 is it then goes on to say may include. So I submit the difficulty with 17.2 is that it is not clear, and it also seems to give very wide discretion. And the minister on the face could include virtually no power of revocation except a power of revocation on the most gravest conceivable circumstances. So I respectfully submit it's not easy to see quite what it is to be read into the words are as opposed to may in section 17.2. But in any event, my lords, insofar as I need to establish there was no right to revoke, I say that clause 9 of the license is undoubtedly a sanction, and in practice, one which amounts to a right to revoke. I accept my Lord Briggs's, but it's a rather unusual right to revoke in the sense that it's one that arises when the licensee tells the minister what's happened. But in my submission, there's nothing particularly unusual in that. It still amounts to a revocation of a license. My lords, perhaps it's a volume 1. It's page 120. Need 121. It is, the reason I say that, my lords, is when you look at clause 9, it's mandatory. The licensee has to tell the minister what's happened. It could, in other words, the only curiosity is the last two lines. This license shall be determined by the licensee, giving notice thereof to the minister. Well, if you just missed out the words giving notice thereof to the minister, there'd be no problem. So I submit this is a sanction within the meaning of the Act, and also properly speaking. My Lord Lascelles.
Yes. I thought that you told us before that the word licensee there is a reference to NP.
Yes.
I was understanding what you were just telling us, that there's an obligation on the licensee, i.e. Prakash, notify.
Yes. Sorry, my lord, the marketing licensee is NP, yes. Forgive me, I've not been clear. The marketing licensee is NP. So if the license comes to an end, sorry, if the agreement between NP and Prakash comes to an end, any cause whatsoever, or if Prakash relinquishes the license, then this license shall be determined.
But as I now read it, that seems to be requiring Prakash in that eventuality to give notice to the minister. Is that what you're saying?
Yes, I am accepting that's the meaning of the clause, but I'm saying that is not a point which goes to its substance. Its substance is that the license does terminate upon the termination of the arrangements as between NP and Prakash. And that will happen if Prakash is in breach of his obligations to NP. So I submit this can properly be said to be A, a sanction, and B, a power to revoke. Or rather, an actual imposition of a clause which says the license will be revoked in these circumstances. The only oddity being the words at the end requiring Prakash to give notice. But if you'd taken those words out, you would have a straightforward termination and power of termination. My learned friend, who I think made a point about interim injunctions, and he said, effectively, why shouldn't the minister have a power to suspend, and why should he go off to court? In my submission, the facts of this case are precisely the answer, because it's an uncontrolled power to suspend. And especially when you're talking about licenses which are annual licenses, it's highly undesirable, if I may put it, that the minister should have an uncontrolled power of suspension, rather than what a court-controlled power would obviously there be restrictions put, and indeed there would no doubt be a speedy trial, something, if an interim injunction is obtained. On section 33, my learned friend says this amounts to anyway a power to revoke. In my respectful submission, it doesn't. The wording doesn't help. I think because of the point that Lord Sales took, namely, it's not talking about terms in a license. It's merely talking. It presupposes that you're talking about permissions and so forth. That may no doubt be pursuant to a license when the license already exists. So in my submission, 33.1 is not what you might call imposing some sort of general power to revoke or vary the license itself. It's simply talking about a power to revoke some permission which may have been given pursuant to the license law, outside the terms of the license. My lords, in particular, if you look at section 33, subsection 4, This doesn't seem at all likely, and at all likely provision in the context of a general power to revoke a license. And again, it's not talking about revocation of licenses here at all. In my submission, this is talking about permissions as opposed to licenses. My lords, the next question is: was this really a suspension rather than a revocation? In my submission, I've made my submissions already, but it's important to bear in mind that, of course, the appellants, as continuing licensees, they'd been licensees for a long time by 2012, and indeed the structure of the Act is that licensees have a reasonable expectation of renewal. And we refer in our case at paragraph 60, subsection 3, that's at E2091, to an extract from De Smith, which makes the point that have an expectation of renewal when you are in the position of a licensee. So this is not just a case of some bare license. It's actually a license with a some reasonable expectation of a renewal on the same terms. And I do submit that the length of time is important. One cannot simply say, well, this was a rather long suspension. If the suspension was well beyond what, on the face of it, one would expect a suspension to be, it was open to the judge, and this is my submission, open to the judge to say that was tantamount to. My lords, as far as damages are concerned, I respectfully submit that there's no reason at all why, under the Act, the court cannot order damages for wrongful termination. The purpose of the Act is to enable the disappointed licensee to obtain reparation. What the method is by arbitration, but it's quite plain that if, in fact, court action is begun and the minister doesn't go to arbitration, there's no reason why, as a matter of consent between the parties, the matter, or implied consent, the matter can't be determined by the High Court. And as far as the constitutional point is concerned, my lords, one can imagine all sorts of different suspensions. Supposing you had a suspension which occurs 5 days before the termination of the license. You might then say, well, it's a genuine suspension, and it may be, that may not be such as to amount to a deprivation of property. But where it has been, as here, undoubtedly a long suspension on any footing, in the case of Prakash, it's been from the end of November 2012 to the end of his license was December 2013. And in the case of Adesh, to the 1st of May 2000, or 2014. Then in those circumstances, I submit that's plainly a sufficiently long period of time for the interference to amount to an interference with the enjoyment of property. And that's because the business, one can actually say the business itself has been substantial. Then as far as the question of what period of time should damages run for, my lords, I submit one has to see what, if one analyzes the breach as the wrongful suspension, then it's entitled to damages, indeed wrongful revocation, are entitled to damages for all the reasonable consequences. One of the reasonable consequences of that is that they were kept out of their premises until, well, frankly now, or until they were kept out of their business for a very long time. The only thing that can be said against it is, oh, well, you didn't apply for a license while you were being kept out of the business, which their answer is, the short answer is, they have all the time been seeking an order for mandamus. So what was the point? And this is a case where, this is not a case where, so to speak, the failure to apply for a license could fairly be said to have broken the chain of causation between the original wrong and the loss. There's no one suggesting for 2 seconds that my clients would have actually been given the license. So, my lords, that's what we say about damage. That's the right way, and that would apply under the Act or under the Constitution. My lords, as far as the question of relief is concerned, Lord Hodge asked me before lunch, what do we want? Well, my lords, in our case, we've asked for the judge's judgment to be restored and the order to be restored, which is at bundle 5, pages 1749 and 1751. Now, my lords, if I can just do that for the moment, I accept that it may be difficult to ask the court now to give me all that relief for the passage of time. Relief in both cases is identical. So, hello.
The line went dead. You've just come back, I think.
Ah, sorry. I think I turned away for a moment. The page is volume 5, page 1748. And this is the order made in Addison's case, but I think order in both cases is identical. And you can see on 1748, there is a declaration that is made. And we would ask for declaration number 1 to be restored. Declaration 2, my lords, I can see might be said that given the passage of time, might be a bit ambitious to ask for a license which has expired 6 years ago to be resumed. And my lords, if I may, I'll come back to that in a moment, because your lordships may feel, well, it's not for you to tell the minister what to do. But subsection 3, we would ask the court to uphold if you're with us on the point about procedural unfairness. If not, it may not matter very much. We have declaration number 1. And then, as far as the order itself is concerned, we would ask for paragraph 1 to be maintained, paragraph 2 very much to be maintained, and paragraph 3, well, obviously costs and so forth. We would ask for those to maintain, restored as well. My lords, the only question arises, well, what about the declaration that we're entitled to a license? My lords, I realistically accept that with this passage of time, your lordship would not be right for your lordship, so to speak, to tell the minister what to do, given that so much time has gone by, 6 or 7 years. I mean, we are unfortunately in that position. That, in my submission, is very much a reason why damages should not be limited, because what is so unsatisfactory is that if let us say, the judge's order had been complied with, we'd be back in business. We've been out of business if we're right, because of an appeal to the Court of Appeal which shouldn't have succeeded and has only been reversed now. I submit that's all the more reason why damages should continue beyond the short date, I'd suggest, by my learned friend. My lords, I think the most we could ask for is that the minister consider such application, if any, as the appellants make, give proper consideration to such application as the appellants make for restoration or accurately, for further licenses in relation to the 2 premises in question. Now, on that, I'm instructed that Prakash is the owner of the premises. They're pretty dilapidated, but he has been able to get back in, albeit, of course, without being able to run his business, from the 1st of March 2017. In relation to Adesh, we're not entirely sure of the position, but he was holding his tenant, but we're not sure what the terms of his lease were. And we are, as we understand it, he has not been back to his premises since being excluded from them, and that no one is running any business from them at all. So we're not sure what the landlord has done with it. My lords, unless there's anything else which anything I've missed, those are our submissions in reply.
Mr. Knox, thank you very much. And also, as I said to Mr. thank you for your succinct and clear submissions. The board is very grateful to council for conducting this appeal in what have been difficult circumstances. I would also wish to convey our gratitude to the legal teams who have assisted in the preparation of this appeal and who have been watching events as they hand out from some distance. The board will now take time to consider the submissions and the documents which the parties have put forward and will give judgment in due course. The board will now adjourn. Thank you.